Hi, I'm Helen Ward, President of Kids First Parent Association of Canada, and I'm giving a four-part video presentation on parent-child rights and education in Canada, and this is part 3. I'm going to get into the how-to of making a complaint and taking legal action. So let's get right into it. Share screen, here we go. Okay, so we're going to discuss how to make a complaint and take legal action. So we're going to go through information that applies to all appeals. Complaints are called appeals. And then we'll get into appeals through the district, the school district system, and then through appeals through the professional regulatory system. So whatever kind of appeal you're doing, don't waste your time. Do not appeal or complain to the school board, and do not complain to the office of the ombudsperson. Those are not necessary. They're a waste of your time. Don't do them. I'm going to talk about these terms: adverse effect, harm, and risk of harm. These are terms in human rights and family and child protection law. You will need to give comprehensive details of all the adverse effects, harms, and risk of harms caused by the education personnel's decisions. Decisions are anything they do or do not do, anything they say or do not say. Do not understate these negative impacts. Understating negative impacts or not providing this information weakens your complaint and possibly makes your complaint irrelevant. So do not understate. And adverse impacts that you need to include will be impacts to your charter rights and freedoms, to provincial human rights laws, to public trust in the education system and your own trust in the education system, to dignity, education, academics, cognitive ability, emotions, mental health, physical well-being and health, relationships, family, siblings, parent-child relationships, school relationships, community, neighborhood, and perhaps job work relationships, to finances, to your time, including loss of time, to your reputation and status in the community, to future options for your child or yourself, to career prospects for your child or yourself, to things like scholarships or educational benefits. These adverse impacts are essential. These are just some examples, but these are pretty key ones. And you want to include adverse impacts that are happening to the children, to yourself, parents, siblings, other family members, grandparents could even be negatively impacted, friends, friendships, others in the school community, and the community at large. Avoid oral complaints. Appeal in writing. Like, you are welcome to appeal orally, but don't waste your time. Don't do that. So why not? Why not just meet and talk it out? Because during a conversation, you may be distracted or say things that harm your case. And you may need to take your complaint or appeal to a court. And in court, written documents are much easier and cheaper to use. Written documents include letters, emails, texts, notes, anything that's written. But if you do decide to meet and speak to the person, which I'm again discouraging, you will need usable evidence. So you need to record conversations, and your recording needs to be a very good quality. So if you want to record a conversation, you do not need to ask for consent to record a conversation that you are taking part in. If you're a party of the conversation, you don't need to ask for permission. Usually if you ask permission, they will say no. And you can record without their consent or their knowledge. They don't need to know that you're recording. You don't need to ask them. So this might sound controversial, but this is what you might consider doing. But if you're going to go to court, you will need a transcript of your conversation and a written version of everything that was said. And that's what you need to use in court. And that transcript has to be a legally usable certified transcript, and that's expensive. It's very expensive. So just don't bother talking to them. If you really want to talk to them, this is what you're going to need. So uh, this is why I would discourage confronting them and speaking to them. Just do it in writing, back and forth. You need to make a comprehensive complaint. Why? You cannot add more issues or more evidence to a complaint when you take your complaint to a higher level, to court or to a higher appeal court. You have to have everything there at the beginning. We'll get to this superintendent part. So your initial complaint needs to include all the violations related to board bylaws and policies or professional codes of conduct of the teachers, principals, counselors, youth workers, violations of the School Act, violations of Provincial Human Rights Code, violations of the Charter of Rights and Freedoms, and violations of international agreements related to children and parents' rights. This is sounding really intense. But created a report and checklist form that you can use. This report, form, and checklist for challenging learning resources and education personnel decisions. It will be put up and you'll be able to download it. It's basically a checklist with all these things on it, so you don't need to reinvent the wheel. So what to include in your appeal, like what happened, when, who was involved, perhaps written statements from parents, those will be affidavits in the end, and students about what happened and how they were affected by the decision. And again, these violations of policies and laws. You also need to include a remedy. So remedy means legally what you want to happen, what will resolve the situation. And you need to be creative about that. Maybe you want an apology, you want an exemption, you want the curriculum to be changed, you want other people's beliefs to be equally represented. You want learning resources removed or include other learning resources. You want the staff to have sensitivity training. You want financial compensation for harms. Like this can happen in court. And you want the staff to be disciplined or dismissed. Think about what would resolve the situation and include that. So think about it. Is there a broad public interest element to your complaint? Chances are there is. And are you doing this appeal jointly with other parents and other members of the public? I would suggest getting together with other parents. So going the legal distance. So you may need to make an appeal that could be usable in court and possibly in appeals to higher courts. So this is a problem with laws that impact and institutions that impact parents and children, because honoring parents and children's rights sometimes requires going to court and then maybe going to the appeal court and then maybe going to the Supreme Court of Canada. This doesn't happen very much with parent-child cases, and so there's not a lot of legal precedent. You'll need expert legal advice as well as supportive groups and individuals to fund your legal action. You should not be alone in doing this. But don't be discouraged from making a complaint. First, you need to try to resolve the complaint at the local level, but expect that your complaint will fall on deaf ears at the local level. You still need to go through these steps. These are necessary steps. Expect that you will need to bring your complaint before a judge for a proper hearing. Other parents and groups will need to support your legal costs, and you'll need lawyers to represent you, so you don't do all the work alone. You cannot do this all on your own. There's possible legal allies. There are advocacy groups that do or fund legal action for various things: women's rights, privacy and consent rights, sexual orientation, gender identity and expression, charter rights, faith groups, freedom of belief groups, individuals with disabilities. There's groups for those folks, and for Indigenous people, for prisoners, and all this. These groups may be helpful, but they might not be interested in defending parents and children's rights, which is our specific issue. Some groups that assist with legal action are listed here. You can stop and look at what these might be. There's other ones too. And Kids First Parent Association of Canada is also that's our group, sometimes would help with that. You could check these groups out, and there's other ones. And other things you can do is crowdfunding through GoFundMe, Give, Send, Go, or other families or groups that share your concerns. So I'm just going to give an example of an actual response from a teacher to parents email from just last year. Parents made a polite request by email to the teacher. Teacher responded, "It is with deep sadness that I am announcing my resignation from the school. I opened my email this morning to read 2 letters from families upset that I will be honoring students' pronouns this year. These families cited religious and spiritual beliefs as the excuse for their intolerance and bigotry. I am still shaken up after reading these emails. As a teacher, creating a safe space for all students is of paramount importance to me. I will not bow down to bigotry and intolerance, nor will I pretend that these are acceptable views in the 21st century." Was the actual response. What was wrong with the teacher's response from a legal point of view? Well, privacy and confidentiality were violated. The email was sent to a group of parents, not just to the parents who were complaining. The charter was violated, that the parents' sincerely held religious beliefs and conscience beliefs are protected, as well as parents also have the liberty right to raise their children in accordance with our beliefs. The Human Rights Code prohibits discrimination based on religion and family status. That was also violated. Privacy rights. Children also have the right to privacy as determined by their parents and not by education personnel. So when children are asked to divulge personal information, that's maybe violating their privacy rights. Also, the BC Teachers and the BC Teachers Federations, that's the unions, Code of Professional Conduct was violated. The teacher violated the parents and the children by belittling and attacking the parents and not treating all students and parents with equality, respect, tolerance, and dignity. Also, teachers are not permitted to use their privileged position for their own ideological advantage. Okay, so first we're going to go through the nuts and bolts of making a complaint through the district system and then through the professional regulation system. So the district system first. And the goal with both of these issues is to get to a judicial review, which is in the it would be in the BC Supreme Court. In different provinces is a different court. A judicial review, that's what the process is called, to change the policy. So first, to do a judicial review, first you need an administrative review. That's what you're going to go through at the local level, which I'll explain, then a judicial review. And if necessary, you go to an appeal court. And if necessary, you go to the Supreme Court of Canada. It's in the judicial review, the judge can quash the decision, order changes, or order financial compensation for the harms that have taken place. So complaint through the district system. First, find your school district's policies, bylaws, and administrative procedures. These will be on the district's website, probably under board. I'm giving BC examples. Other territories are similar, but not the same. You have to check your own information. So here, if the school's in Nelson, BC, here's their website. There's the Board of Education tab. Then you would go to Board Policies. There we go, Board Policies. Then look for the bylaw or policy or administrative procedure related to appeals. Appeals are complaints, okay? So there's a bylaw, appeal. There we go. So appeal means complaint, and decision means anything an employee did or did not do, including what was said or not said. So those are called legally decisions. Appeal an employee's decision, okay? It will require that the decisions significantly affect the education, health, or safety of the student. Okay. I'll get back to that soon. You need to find bylaws or policies or administrative procedures that have been violated. So some of these that might be relevant in your situation are the opt-out ones. Remember, it's not called opt-out, it's called alternative delivery. So sensitive issues and alternative delivery of the curriculum, alternative delivery in the physical and health education curriculum, or policies related to learning resources, or maybe use of social media learning, or these are just examples from this one district. Equitable and inclusive education services for learners, so everybody's supposed to be included. Freedom of information and protection of privacy may be an issue. Cell phones and personal electronic devices, sexual orientation and gender identity policies, anti-racism and cultural safety policies. I mean, these are just some suggestions, but you have to look at what the policies are called in your district. Some boards actually don't have required policies related to learning resource selection and appeal policies. Like this Kootenai Lake district didn't have policies that they're supposed to have. So most districts require that you go first when you're making a complaint, an appeal. You first must go to the employee, for example, the teacher, the counselor, the librarian who made the decision. So go first to the employee making the initial decision. Okay? As oral and writing, remember, don't talk. Right. You need evidence that the decisions affected or significantly affected the student's education, health, and safety. And you will need decisions that infringe the parents' and the students' rights, or the students' rights, or that harmed public trust in teachers or in the education system, that the employee violated professional code of conduct. So this issue of being significant, because the court could throw it out that they might say it's not significant. So it may be necessary to legally challenge the district policy that seeks to restrict appeals to a narrow range of issues considered significant, because human rights laws prohibit discrimination. The Supreme Court of Canada requires that our charter rights and freedoms be interpreted broadly, not narrowly. So who decides what is significant? So this is why you need to stress the harms that have been caused by whatever the violation was. They might want to say that, oh, it's just a little minor thing, it's no big deal. So education, health, and safety must be broadly defined and include respecting rights, non-discrimination, emotional and physical well-being, a non-poisoned education environment, and trust. So discrimination can significantly affect education, health, and safety. These are and undermining the trust, public trust, or the family's trust in the education system. These, you have to interpret these, make sure that they're understood to be significant if you're making a complaint through the board system. So you're going to send the person, possibly the teacher, the librarian, a polite email with the complaint attached. We have developed a report it's a report form and checklist for challenging learning resources and education personnel decisions. I'm sorry I can't give you the URL right now, but we will get that up and available and widely disseminated. It's basically a checklist. You don't have to think about everything, you just check things off. If you're not satisfied with that initial response from the teacher, librarian, whichever staff, then you need to go to their supervisor, which is usually the principal, so their immediate supervisor. Okay. And you might want to add to your appeal if you need to. If the response from the staff, like the teacher, whoever, also violates policies, codes of conduct, professional codes of ethics, or you and your children's rights and freedoms, then include that in your appeal to the principal. Remember, a decision means any action or non-action, what was said and not said. Perhaps the teacher was not respectful to you when you presented the email. I don't know. If you're not satisfied with the principal's response, then the next one goes to the superintendent of schools, and this one must be in writing. And this is the key one. This is where you really want to get to. So the appellant may appeal to the superintendent of schools. There we go. Within 30 calendar days. So get this thing going quickly. And then there will be a policy about how long they have to respond here. This one is 10 calendar days. So it's a quick process. Again, you might need to add to your appeal if the response from the principal also violated policies and codes of conduct. Add that in to the appeal to the superintendent. So the superintendent must respond within a short period. So it's like 10 calendar days. That's good. It's not dragging out. So the superintendent's written response is legally considered an administrative review of a decision. Okay, that's an administrative review. Remember that word. That's what you need to take to a judicial review. Now the board policies will tell you that the next step is appealing to the board. Okay? Don't do that. Do not appeal to the board. It's a waste of time your unpaid time. School boards do not have legal expertise, and they are not a court or tribunal. School boards do not control curriculum or learning resource policy. School boards are 100% under the Ministry of Education or Ministry of Education Childcare in BC at the provincial government. So don't go to the school board. And don't go to the ombudsperson. They might tell you to do that, advise you to do that. That also, the ombudsperson has no power to enforce any law or policy. Don't waste your time. If you want to add to your appeal, if the response from the superintendent was also a problematic response, violated codes of conduct or your rights and freedoms, you add that in when you go for judicial review. So now you're at this judicial review point. You've got that administrative review from the superintendent. You're going to go in BC. It's the BC Supreme Court. It's different. Courts have different names, different provinces. And the lawyer needs to make an application to court, and the judge would review the administrative review to see if policies, procedures, and laws were followed. And your case is against the king, in the form of the provincial government. When we're dealing with charter issues, the lawyer needs to serve the respondent, that's the government, Ministry of Education and Childcare in BC, with a charter notice. So a notice of charter application must be included if you're raising charter issues. And that notice includes the sections of the charter that are at issue, and very quickly how they are violated, and the remedy, the solutions that you're going to be seeking. Again, we have this report, this checklist form. Sorry, it's not. We'll disseminate the location of that, or so you can download it very soon. Now, so that was the repealing through the board system, the school district system. Now, this is making a complaint through the professional regulation system. Okay. So again, we want to get an administrative review and then a judicial review. That's what might need to happen here it's in the BC Supreme Court. So complaining about resource selection through teacher regulations may be a waste of time, because it's not, the teacher doesn't set these. The BC Ministry of Education and Childcare sets the curriculum, which now in all grades mandates violations of students' personal boundaries. So if you've got problems with that, we've discussed that in the previous video. It's not the teacher's fault. They're following the curriculum. And also teachers have professional autonomy to choose learning resources. So that makes it more difficult to complain about their resources that they choose. And how they interpret the curriculum, also professional autonomy there. And also the curriculum is very vague. So a teacher could choose anything, and you could say that, and they could easily defend their choices, their decisions. It's hard to prove that what a teacher does or chooses as a resource is inappropriate. I mean, it's not impossible in some outrageous situations, but that's a challenge with this process. So, but the BC teachers have professional standards. We're going to read through these standards, show you where they are, and decide if any of these standards are not being followed. You can include a specific standard and how it was not followed in your complaint. And these standards can also be used in the appeals to the district process because they're still relevant. They tell us what's appropriate and what's not appropriate in a classroom or in a school setting. So other kinds of violations for professional standards, and we'll look at these closely, include using the teacher's privileged position for personal advantage, including ideological advantage or financial or political advantage. And teachers in and out of school must behave in a way, they're held to higher standard. So their behavior inside of school and outside of school cannot lead to public distrust in teachers, in the profession, or in the whole education system. Their behavior must not create what's called a poisoned educational environment. That's behavior inside the school system setting or outside of it. And they must always treating students or parents with disrespect is not okay. And discriminating against students or parents' religion, race, culture, beliefs, sex, sexual orientation, gender identity or expression, disability, family status or marital status of the parents or the kids is not okay. Also, violating students or parents' privacy is not okay. So these are all things in the code of ethics. So the BCTF, the Teachers Union, has a code of ethics. That's not the one that's going to use, but it's similar. Here again, it says a privileged relationship exists between members and students, between the teachers and students. A member refrains from exploiting that relationship for material, ideological, or other advantage. In BC, the BC government now regulates the teaching profession. There's no more College of Teachers doing that. It doesn't do that anymore. It's BC regulatory body. So standards, here we go. Here is the document that has their professional standards for BC educators. So educators value the success of all students. Educators care for students and act in their best interest. Educators have a privileged position of power and trust. Educators are responsible for the physical and emotional safety of students. Educators respect the value and diversity in their classrooms, schools, and communities, inclusive of First Nations, Inuit, and Métis, and other worldviews and perspectives. Scroll down, just look down here a bit. Educators do not abuse or exploit students or minors for personal, sexual, ideological, material, or other advantage. So anything in here that you feel applies to your situation. Educators treat students with equitably with acceptance, dignity, and respect. Educators understand the importance of confidentiality and protect students' privacy, which we know these things are often violated. The standard one, yes, it's ideological advantage issue. Educators act ethically and maintain the integrity, credibility, and reputation of the profession. Educators are role models. Educators are held to a higher standard and are accountable for their conduct on duty and off duty. Okay. Educators understand and apply knowledge of student growth and development. Cultural identity, ways of being and worldviews. And they create a positive, safe, and inclusive learning environment to best meet the diverse needs of students. Well, we know that a lot of families do not feel included and are leaving the system or are very uncomfortable being in it. These are all complaints that you could make in the professional regulatory complaint or include this in a complaint through the district system. Here, educators value the involvement and support of parents, guardians, family, and communities in schools. Educators understand, respect, and encourage the participation of families and communities in student learning and development. Like a lot of people don't see that. Educators consider the perspectives of parents, guardians regarding their children. They consider the perspectives. It's not very strong language. Okay, there we go. Educators communicate effectively and in a timely manner with parents and guardians. So we can pause here. They create a respectful, inclusive environments for student learning and development. Okay. Yeah. So in this complaint system, there is a form we're going to get to. Oh, also, other teachers have a duty to report a teacher they think is out of line. I'm sure boards also have a responsibility to report teachers that are out of line. I don't think they usually do this, but any member of the public, so not just the parents and the students, any member of the public can make a complaint about a teacher. So this, when parents are reluctant to do this for relational reasons, business reasons, employment reasons, or whatever, somebody else in the public, maybe a grandparent, maybe a friend of the family, maybe somebody else can make the complaint. Okay? Because this is a public education system that needs to respect the public. Again, a complaint in writing, go to the teacher first. It's the same process. The teacher first, then the principal, and follow whatever the policy is. They have a complaint form. Yep, there we go. Complaint form, you must, okay. So here's the click to the complaint form. There it is. Pretty straightforward. And again, they want to remedy. What steps have you taken to resolve your concerns at the school level, and what was the outcome? So you have to do these steps. Go to the principal, the teacher, then the principal first. And again, the remedy, what do you want to happen to resolve the situation? Again, you can use these report and checklist form that will be made available so you don't have to figure everything out yourself. You can check off the boxes that apply to you. And the teacher's conduct regulation appeal, it may lead to a kind of court-like process in the professional regulatory system. And they might discipline the teacher or they might not. If you are not happy with the regulator's decision, then you can appeal that to a higher court. And here would be the BC Supreme Court and as a judicial review. The lawyer, again, would include a notice of charter application to the court if you're raising charter issues, which I would think he would be doing. Okay, so this is the end of part 3. So gone over how the sort of step-by-step process of how to make your complaint. I hope this is helpful, and thank you for listening. And stay tuned, and please listen to part 4, which will be about parents and children's rights. But this part 3 is your nuts and bolts how-to information. Hope that's been helpful. So thank you.